So, Allie, everyone in our field is talking about something called Chevron deference. Can you just tell us what that is?
Yeah, so this Chevron Deference Doctrine comes out of a Supreme Court decision during the Reagan era, and it states that federal agencies are able to interpret statutes from Congress related to the regulations that they're working on. And at the first, this was really championed by Scalia and other conservative justices on the Supreme Court, because at the time the Supreme Court was quite liberal, and so they could take power away from the liberal Supreme Court and give it to the agencies to very narrowly interpret civil rights legislation that was happening. And then as we move into the many administrations later, the Obama administration, the Chevron deference doctrine is used by courts to uphold things like greenhouse gas regulations and Dodd-Frank Act regulations. And so Scalia and his allies on the court start to no longer like the Chevron doctrine. And so that brings us to today. So Tom, do you want to tell us a little bit about what happened with the Chevron doctrine this summer?
Right. So, according to these justices, it used to be good and now it's bad. And so there was a case brought to them a couple of years ago called Loper Bright, and they decided it just this summer, and they basically completely nullified the Chevron doctrine, and they threw interpretation of ambiguous ambiguous statutes back to the courts. Now, this is very convenient because it basically, like all the time since the original Chevron ruling, there's been this effort to stack the court with conservative judges, with judges who are anti-regulation. And this is, from lower federal courts all the way up to SCOTUS. And so all of a sudden, you've got what is basically a judicial power grab. And one of the justices who voted against this ruling was Associate Justice Elena Kagan. And she put it, really succinctly that with this case, the conservative majority on the court turns itself into, quote, the country's administrative czar. So basically, what you have here is a power grab, taking away power from federal agencies and the experts that they hire to, sort of your EPA type of people who, they hire scientists to interpret these rules, and putting it right back on the courts at a time when the courts are very, very conservative. And I wonder if you could talk a little bit about, what that means overall for regulation, because, we've had, many decades of Chevron doctrine being in place for regulations. What happens now?
Yeah, so legal experts are saying that regulators are going to be a lot more hesitant to pass any sort of regulations. And that's not a great thing for those of us that care about the environment and public health. And one of the main reasons they are going to be more hesitant is because this opens the door for industry groups and corporations to sue the agencies for their regulations. And also that these industry groups and these corporations can shop around for judges that align with their political beliefs. Do you want to talk a little bit about how this decision might impact industrial animal operations?
For the whole industrial meat world, it's kind of ironic because this is an industry, as we sort of document in our center here, that tends to be pretty lightly regulated. There are so many regulatory gaps. And these big meat companies are very powerful and very good at lobbying and, gaining influence in these agencies like USDA, like EPA. And what this does is it takes an already bad situation and potentially makes it even worse. And there's, one case that I've been looking at recently is the USDA. Back in the 2008 Farm Bill, the USDA was charged with coming up with rules to make a more fair situation for livestock farmers. And the idea is that livestock farmers work on contract with these big integrators, or big meat companies, and they have very little power. The big companies dictate to them, how they can grow their stuff, how they can grow their animals. They, basically capture most of the profits in it. They have them competing against each other to maximize the company's own profits. And so there's been a lot of pushback against this, and it's been an incredibly vexed process. Congress since then has nullified it a couple times in later farm bills, And finally, this year, 2024, so, almost 2 decades later, the USDA comes out with a new set of rules that are pretty well liked by some of the advocates in the space. And the meat industry is already celebrating and sort of rubbing its hands together. There was a statement in Politico from a meat industry trade group saying, "Oh yeah, we're definitely thinking about using the collapse of Chevron in court cases." And another one that we've been looking at is the Environmental Protection Agency, the EPA, and a similar thing has finally come up with a draft rule about regulating pollution from these CAFOs, from these giant industrial farms under the Clean Water Act, which has been an incredibly vexed process. The Clean Water Act is from the early 70s, and they're just now figuring out rules that would bind these giant operations to document their pollution, to limit their pollution. And once again, this is just about to happen, and it's very inconvenient that that Chevron doctrine falls, because that's going to give the industry space to challenge that in court. And like you said earlier, shop for a nice federal judge somewhere. And if they lose that case, they know they've got the Supreme Court back there ready to do their bidding. Another one, getting a little bit off the animal agriculture topic, the EPA just a few months ago came out with new rules regulating PFAS, which are these so-called forever chemicals that are ubiquitous in the United States. They're in our water, they're in our bodies, and the EPA had no limit on PFAS in water. And there's been documented cases all across the country of water systems where people are getting PFAS in their drinking water. And the EPA came out with a rule limiting that, putting a limit on it that's going to cause all kinds of action. Water agencies across the country who have PFAS in their water supply are going to have to figure out how to filter it out. It's a really big deal. And also it could be a boon for public health. PFAS have been tied to lots of different cancers. And this gives the chemical companies that have put this stuff out a very nice way to challenge this rule and take a lot of pressure off of themselves. Now, you've been looking a little bit into what the response could be from Congress to take back some of this power from the judiciary and give it back to the agencies. Talk a little bit about that.
Yeah, so when the Supreme Court made this decision in Loper Bright, they used statutory law and not constitutional law. So that means that Congress could pass a statute to enshrine the Chevron Deference Doctrine into law. And so they could do that in two ways. They could do that kind of when they are passing legislation on a particular topic, like clean water or clean air. They can direct the regulators and say regulators could, where you can use the Chevron deference doctrine here, or they could kind of in one fell swoop and codify Chevron deference into law. And actually, just last week, Senator Warren and some of her allies introduced the Stop Corporate Capture Act, which would do just that, though we don't expect it to pass the Republican-controlled House.
And so here we are right before the election, and we're about to get a new Congress and a new president, and who knows what's going to happen next. But one thing you can count on is that CLF will be watching and reporting on this.